Hello, everyone, and welcome to another episode on Immigration Talk Show. I'm your host, Nipasa, and I'm going to be there with you for this next 1 hour on a very, very interesting discussion with our guest for today. And before we have our guest join us, I have this very important disclaimer to keep in mind. So, friends, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, welcome to Immigration Talk Show. It's really nice that you have joined us. We are streaming live right now on YouTube. And also, you can check us out on LinkedIn, Facebook, X, Instagram. And please feel free to connect with us, friends. And also, don't forget to subscribe to our channel at Immigration Talk Show. And you can also participate in this discussion by commenting wherever you're watching. And also, you can join us on call, maybe ask your questions directly to the attorney. And that you can do so by calling on this number 425-436-6335, and the access code is 988-888. So, yes, and without further ado, friends, today's guest is none other than a very familiar face, attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. And it's always lovely to have you, Chand. I hope you're doing good today as well.
Thank you, Nipasa, and thank you very much. And then hopefully we'll have another very fruitful and very informative session today. We're going to talk about the perms, the relevance of perms, especially to the folks that are on H-1B, working on H-1B in United States, because there are term limits. There are limits on how long somebody can stay in US on a temporary non-immigrant visa, such as H-1B. So we will talk about all the nuances and things concerning the time limits that will help them extend their stay on H-1B in this country.
Right. And friends, it's going to be very interesting. Maybe you can join in with your questions because we're going to be here for the next hour. And yes, we'll be happy to answer to your questions as well. So join us in this discussion. Chand, I'm excited. So I think we should not wait too long. Start off with some of our questions, So I have one first question to you, and that is, if you could tell us about, what happens when an H-1B worker reaches the 6 year limit, since that is also our topic, and, are there any immediate extensions available?
Sure. So one thing that anybody that's on H-1B should realize and remember is the H-1B can only be used for a maximum of 6 years. That's the general rule. And each time somebody applies for a H-1B, they can typically get an approval that is for a max of 3 years. So somebody gets a H-1B, they can get a 3 year H-1B. They go for an extension, they can again get another 3 year H-1B, and the limit for that is 6 years. So the general rule by regulation says somebody can be on H-1B only for 6 years. And the reason for that rule is because H-1B is supposed to be a temporary visa. It's a temporary non-immigrant visa where somebody utilizes H-1B to come and work in United States, but on a temporary basis. So that's how this 6 year rule came about. And then eventually what happened was, what if you need to stay in the country and work for more than 6 years? And the Congress, so basically what happened was they went and the regulations got changed. And the rule is, yes, you can extend the H-1B after being in the United States on H-1B for 6 years if certain conditions are met. And so under certain conditions, they can extend it after 6 years. And the main condition is the green card process should have started. So somebody should have an intent to get a green card. Somebody should have an intent to stay as a long-term permanent resident in United States. Only then somebody is eligible for extensions after they cross 6 years on H-1B. How is this possible? So the first thing is the perm application. So typically people are on H-1B. They need to have a sponsor. They need to have a sponsor, and typically that sponsor is their employer. That employer should sponsor their green card, and they have to be at a certain stage of their green card in order to qualify extensions that cross 6 years. And the way that works is employers typically have to do something called a labor filing, labor uh, perm application. So if the labor certification is filed, it's filed by the employer. That is the very first step when a company tries to sponsor somebody's green card, labor. So if this company sponsors labor, they file the labor. And if that labor certification is pending for more than 12 months, technically, again, they are eligible for extensions. So if somebody's company has filed a labor application, labor, it's called 9089 application. If it is pending for more than 365 days, USCIS will agree for an extension. Or there is something called an I-140. So I-140 is an immigrant petition for an alien worker. Typically, this is again applied by the employer. So if the employer applies for an I-140 and they get an approval, so that is another way where somebody can again get an extension after they cross their 6 years. And again, there are some ways where somebody can self sponsor their I-140. There is something called EB2 NIW, National Interest Waiver. There is something called EB1 A. So there is this process. So if somebody applies for their own I-140 using these categories where they can self sponsor and they have an approval, that is another way where somebody can apply for an extension. And the general rule is, if you're not in the process of getting a green card, if you're not in a spot where you either have an I-140 approved or your labor certification is pending for more than 1 year, you will not be given extensions. So from a general perspective, people have to make sure that if they do want to stay in the country for a longer time and they want to stay and work on H-1B, the only way is they have to get the green card process started, and they have to be at a certain stage to ensure that they can extend their H-1B after 6 years. And if this is not done, the only way they can stay back in this country is by transitioning to another visa type. Maybe if they're eligible for O1, maybe if they're eligible for L1, something like that. They have to transition to another visa type. And if that is not possible, and if they want to stay on H-1B, they have to make sure that either the I-140 is approved or the labor application is pending for more than 365 days.
Thank you so much, Attorney Chand, for highlighting how important is 6 year limit to keep in mind, and also extending at the right time if you are eligible for any extensions as well. So, thank you, and we will discuss further on this. So, stay with us, and also hi to Bhavini. Thank you for joining us on YouTube. We will take up your question, but in some time. So, stay with us. So also, Chand, my next question is about filing a perm. Can filing perm application before the H-1B 6 year limit help extend an employee's stay in the US? I mean, you already discussed about it a bit, but if you can tell us further, and what are the key deadlines, to keep in mind?
Yes. So filing a PERM application. So PERM basically means Program Electronic Review Management. That is that is what the PERM stands for. And from the form perspective, it is called the form 9089. So if this application is filed, and this is done before the 6 year limit is done, under certain circumstances, it can help extend an employee's stay in US. So that is like the first and foremost thing that typically everybody that is on H-1B should aim for. Basically, convincing their employee that they're a valuable employee, and it it makes sense for the company to sponsor their perm process. And perm is a very complex process. It is also expensive for a lot of companies because there are mandatory advertisement that have to be placed. There is a recruitment process that the company has to follow. There is legal fees. So it's a pretty expensive process. Not only expensive, it is also a complex process. So for that reason, a lot of companies typically, unless they see a real good reason, they will not file the perm. And the reason for that is the money and the cost, and also uh, the long term need. So the company has to be convinced that they're hiring somebody, they want somebody to be their employee for a long time to actually sponsor their green card. And once the company is convinced, that is where the company will start filing the perm. And the key deadline is the company has to file the perm before the H-1B workers 6 year limit is reached. And when we talk about 6 years, we're talking about 6 years overall. So it's not just with that particular employer, but the H-1B throughout that employee's time in US. So it is time counting the prior employer's time period, any other employer that the employee might have worked under H-1B, and so on. So the total time with all the employers, former employers together on H-1B is 6 years. The max is 6 years. So before the 6 years limit is crossed, the employer should file for the perm process. And the big rule is, if uh, the perm should not only be filed before 6 years, but the perm also has to be pending for at least 1 year. So if the perm is not pending for at least 1 year, again, you cannot get extensions unless your I-140 is done. So what that means is, you cannot really wait until your sixth year to have the employer file for the perm. So the perm should already be pending for at least 1 year. So what that means is, before your fifth year ends, the company should have filed the perm for you. Because if the company files the perm for somebody before fifth year, then when during the sixth year, when they're ready for their extension, it is already pending for at least 365 days. So the rule is, on the day you want to get an extension filed, the perm should already be pending for 1 year. So the bottom line is, if the company does not file the perm application before fifth year, you are at high risk, because you're getting very close to your sixth year. And once the sixth year is done, unless the perm is pending for pending for 1 year, or the I-140 is complete, you pretty much have to leave the country or convert to another status. So that is like one of the main things with the deadlines. And the other option is I-140 approval. So if the I-140 is approved before your sixth year, you're good. And what that means is, to file the I-140, you require the perm if the employer is sponsoring you. So you have to account for that timeline. If not, what a lot of people are also considering nowadays is EB2 NIW. So EB2 NIW is something that a lot of people should explore. The reason is, if somebody's in the country for such a long time, they're contributing to US and they're working in a field that is of national interest, and you have a very high pay, you more than likely, depending on your credentials, you might qualify for a national interest waiver. And the way it works is, you will file an I-140 under EB2 NIW process, and you can do it in premium. And what that means is, you have to account for the time. So you probably will need about 6 months, because in case you have an RFE, you have to account for that timeline. So if you have about 6 months of time, you can at least explore EB2 NIW option in case you are qualified. So the bottom line is, at least by the end of your fifth year, either your EB2 NIW or hopefully the perm process, if they start, more than likely you are in good shape. So in terms of the key deadlines, you always look at your 6 year limit. So everybody should keep in mind what their 6 year limit is. And based on that, always aim to have the perm filed at least 1 year before that deadline. So that is the crucial deadline that everybody should keep in mind. And if it is not done, you are at risk when the 6 years is done. Because I do know a lot of people who have completed their sixth year, they don't have their perm application pending for at least 1 year, their I-140 is not done, and unfortunately they had to leave the country, they have to go back to India, wait until this entire process is done, and then reapply and then come back to US.
So it's very important. Thank you so much, Chance, for highlighting the deadlines and dates to keep in mind, at least to keep how much buffer time. So 1 year, 365 days at least. So thank you, Chand. And also, hi to Nilanjana. Thank you for joining us with your question on YouTube. We will take them up very soon. So stay with us. Also, Chand, if you could tell us about this. What is the role of an I-140 petition in securing H-1B extensions beyond the 6 year cap?
So in the last few minutes, we talked about two ways that one can get an extension after 6 years. One is uh, by showing that the perm application is pending for at least 1 year. The
Yeah.
other option is I-140 being approved. So these are two ways where somebody can get an extension done, and there is a difference. So if perm is pending for at least 1 year, but your I-140 is not done, what typically happens is, yes, you're eligible for an extension, but you can only get a H-1B for 1 year. So if I-140 is not approved, but perm is pending, one is still eligible to get an extension, but they can only get a 1 year approval. And say the I-140, so I-140 petition. So if the I-140 petition is approved, the beauty is that you are eligible for a 3 year extension. So if I-140 is approved, you're getting a 3 year extension. So the goal, eventual goal, is to see an I-140 petition that is approved. And doing so, you will be guaranteed to get an approval for 3 years when you apply for your H-1B extension. And I-140 approval, again, it's two types. One, an I-140 where your employer is filing for you because they have sponsored the perm application. That is the most common way people get their I-140 done. The second uncommon way is you self-sponsor I-140. You can self-sponsor I-140 under EB-1A category if you qualify, or you can self-sponsor under EB-2 NIW, National Interest Waiver, if you qualify again. So the goal is either you self-sponsor your I-140 if you're qualified, get an approval, or have your employer file the I-140 following the perm process. And after the perm is certified, they file the I-140. And the goal is try to have an I-140 approval before the 6 years, because that will guarantee 3 years of approval. And that's always better than just showing the perm that the perm is pending for 1 year and getting an extension. Okay. And I-140 does impact the H-1B workers stay, because technically without an approved 140, you either have to leave the country, or maybe the max you'll get is a 1 year extension if your I-140 is not approved. And I-140 being approved, you are eligible for 3 year extensions. And also the beauty is that if your I-140 is approved, and the I-140 is approved for at least 180 days, you can even transfer your employment. So down the line, if you get a better offer, you get a better job offer from another employer, you can always change your employer. The I-140 stays with you. So the date, the priority date, and that approval copy stays with you. What that means is you can apply for your spouse's EAD card, H4 EAD, or you can apply for your transfer, even though that I-140 is with the previous employer. That I-140 can still be used to get your 3 year extensions. So even after your 6 year period is done, if your I-140 is approved, so theoretically you can use that approval to keep on extending your H-1B until your dates are current. So the key point is try to get an I-140 approved uh, based on how you're qualified before your 6 year period is done. And doing so, you can guarantee that your H-1B can be extended till the dates are current.
Okay. All right. Thank you so much, Chand. And well, also, what if a perm labor certification is still pending close to the 6 year H-1B limit? So, what options does the applicant have in that case?
Sure. So if the perm labor certification is still pending, what that typically means is the I-140 cannot be filed. Only once the perm labor is certified, the company can sponsor the I-140, can file the I-140. And nowadays, unfortunately, what is happening is perm is taking a very, very, very long time. From the date somebody applies the perm, it is taking almost 15 to 16 months to get a perm labor certification. This was not this way about 2 years back. So what has happened was they changed the perm system. So previously, the perm used to go through a different system. The system used to be called PLC, and now they changed the perm to a new system. Now we use something called flag. We use the flag system for perm labor certifications. And when they made the change, because things got changed a little bit, we are seeing extreme delays in perm labor certifications. So once the perm is filed, a couple of years back, it used to take 4 to 5 months to see the perm certified. Now it is taking almost 15 to 16 months. So, and what that means for everybody is until your perm is certified, your I-140 cannot even be filed. So you not have a I-140 approval. And what that means is tomorrow you can, I mean, tomorrow if you have a very, very good job offer from another company, you cannot even take that job, because if you are close to your 6 year limit, even if you get a job, even if you try to change your job, you might not even be eligible for 3 year extension. So you're in a spot where you can't even take up a good job offer if you get a good job offer, because your perm labor is pending, you're getting close to your 6 year limit, and your I-140 cannot be filed. So So in terms of options, what people typically can do is, if your perm labor is a, if your perm labor, even though it is pending, if at least 365 days have passed, if your perm is pending for more than 365 days, you can at least apply for an extension. The only challenge is you can only get 1 year. So even though technically you can apply for an extension, you're only getting 1 year. And 1 year extensions are always risky, because if you go for stamping, you'll only get a visa for 1 year. And again, after 1 year, again, you have to file your H-1B. And again, we don't know what kind of rules will change in the next 1 year, and so on. So theoretically, the good news is, yes, you can get an extension, but that extension is only for 1 year, and that is only if your perm is pending for 365 days or more. So how do you tackle this? So the way you can tackle this is to get your perm application filed as early as possible. Don't even wait until it is fifth year or sixth year. Your perm has to be filed as early as possible. And what we tell people is, try to work with your employer and try to get it done in the very first year of your employment. Convince your employer, show your work product, convince them that you're a good employee, convince them that you have the talent, and try to convince your employer to file the perm as quickly as possible. If the company is not filing your perm in the first or second year of your employment, it's probably too risky to stick to that employer, because tomorrow when it is time, when it is close to your 6 year time period and your perm is not done, right now we are talking about 15 to 16 months to get the perm application done. But to even file the perm, there is almost a 6 to 8 month of work that needs to be done before the perm is filed. There is something called prevailing wages. The company has to apply for prevailing wages. Prevailing wages take 6 to 7 months. After prevailing wages, the company has to do recruitment. Recruitment is another 2 month process. So by the time you add the prevailing wages, recruitment, applying for the perm labor, and then applying for the I-140, you're looking at almost 2 to 3 years nowadays. So if you are working for a company that is delaying your perm process, you are at risk. You are at risk for 6 year. Once you cross your 6 years, you are at risk for getting extensions done. In case something happens to the perm, you get a perm audit and say the perm fails, tomorrow you are at huge risk. So for that reason, what I think everybody should do is file perm as early as possible to maximize that your extension will not have any issues. And again, if your employer doesn't look like they're filing the I-140 or perm pretty quickly, explore the EB2 NAW options, explore the EB1A options, and see if it is something that you might qualify. And another option is, look at the O1 visa option. So the O1 visa does not have the 6 year limit, and a lot of people who are who do have extraordinary ability in their field might qualify for O1 visa, and a lot of people are exploring the O1 visa option. So O1 visa option is another option that people can explore if they feel that their perm is getting delayed. So if not, you are at risk. Uh, so so what it means is, uh, do apply for perm, do make your company apply for perm as early on as possible. And if you feel that the company is delaying your perm, and it is dragging the process, you might have to explore finding a job with another company, because you don't want to work with a company where tomorrow they're not doing the perm processing on time. Because what that would mean is, by the time your 6 years is over, you might even have to step out of the country, you might have to leave the country, because you're not getting an H-1B extension done.
Thank you so much, Chand, for taking that up as well, and also, for highlighting how important it is. So, hi to Ganesh. Thank you so much for joining us. I think we should quickly address some of our viewers' questions. Let's start with Bhavini. I'm currently in my fifth year of H-1B, and my employer just started my PERM process. Given that PERM can take months, what happens if I hit my 6 year limit before my I-140 is approved? Can I stay in the US while waiting?
So at least the good thing is, looks like your employer has actually started the perm. And so right before your 6 years expires, so your H-1B approval copy, you can see when your current H-1B expires. So before that date, your company will have to apply for an extension. So so when they are applying for your extension, if they've already crossed 365 days of filing the perm, you probably will not have any issue. Even if your I-140 is not approved, they can still ask for an extension. The only problem is, you only get a 1 year extension, not a 3 year extension, but at least you can get an extension. And if it is fifth year, The big challenge is the perm itself. After applying the perm, it is taking almost 15 to 16 months to see an approval. And then you have to file an I-140. The good news with I-140 is you can do it in premium processing. You cannot file the perm in premium processing, but you can file the I-140 in premium processing. So if luckily just before your extension is required, if your perm gets approved, you might be able to do your I-140 in premium. But worst case, if the perm on that day, the day your extension is required to be filed, if your perm has crossed 365 days, yes, you're good. If not, this is what you should do. There is something called recapture. So recapture means, say you travel out of the country, you stay in India for a month, or in the past you have traveled to India, you've taken a vacation, you've traveled to some other countries. You can count all those days, and you can recapture all that time and add it to your 6 year period. So what that means is, 6 years is the time you're able to physically stay and work in this country on H-1B. It is not the approval time period. So in the 6 years, whatever vacations you have taken and gone out of the country, you can count all those days and you can do something called recapture. And those days can be tagged on, can be added on to top of 6 years, and they can extend your H-1B. So what you should do is check with your company and see how much of recapture time you have. That can be added. And then the next thing is, see if your perm is going to be pending for at least 1 year by the time your extension is due. So doing so, you can add and get your extension done.
Very interesting. And thank you so much, Sean, for taking that up for Bhavini. And recapture is another very interesting, way, I think, to count your days. So, yes. And we have Nilanjana now. Nilanjana. My employer started my perm process late, and I only have 10 months left on my H-1B. If the perm gets delayed or denied, am I out of options or can I still extend my stay?
So looks like you have 10 months stay left, and then you again you said the employer started the perm process late. Uh, at this point of time, if the perm is already filed, I think you're in good shape because you have 10 months of time and the perm is already filed. I think you'll be okay because you can always uh, look for recapture option because it's only 2 months. You might be able to recapture it pretty easily by working out of the country. But if the perm process has just started, but the perm is not actually filed, then I think you are at risk because when you say the perm process has started, they start off with the prevailing wage process. Then they do the advertisements and mandatory recruitment and so on. So that will take a long time. So the whole thing is, if your perm is already filed, I think you're in good shape. If your perm is not filed yet, just check and see with your company how quickly are they going to be filing the perm, filing the actual perm with DOL, and then talk to them about recapture because people can always use recapture, stay out of the country, and all the time can be added on. So you definitely will have to talk and see the exact date your perm was filed. You do need to get that date, the date that perm was filed with DOL. Normally, what happens is when the perm is filed with DOL, your employer will get an email. So that email is good proof that the perm is filed. So try to get a copy of that email so you exactly know when the perm was filed. And then look at all your recapture options, how much time you have spent outside the country, because all that can be recaptured. So anytime you take a vacation, go out of the country, you can recapture and add it to the 6 year period.
All right. Thank you so much, Nilanjana, for participating with your question, and also Chand for being such a sport and answering so patiently. So we do have Ganesh's question. Sudhir, hi Sudhir, thank you for joining us on YouTube. Stay with us. So we'll just go for a short break quickly and be back here on Immigration Talk Show. And today, friends, we are discussing with attorney Chand Parvathaneni from Dallas, Texas, about reaching the H-1B 6 year limit and what are your options with firm. So, yes, you can also have a one on one discussion with Attorney Chand himself, maybe about your case. You need some private time and a consultation. Why not call him up on his number, 817-523-8247? Or else, yes, you can email him at law@spblawfirm.com and go visit www.spblawfirm.com. So now, friends, we'll just go for a short break. Don't go anywhere. It's me, Nipasa, with Attorney Chand Parvathaneni. Hello, everyone, and welcome back to Immigration Talk Show. And this will be the second part of this discussion we're having with Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. And it's always wonderful to have you here, Chand. Always a pleasure to have you on our shows and discussing about so many various topics, including this one today. So, Chand, we have been answering some of our questions from the viewers. So let's continue and let's take up this next one from Ganesh. So Ganesh is asking,
Mhm.
I have an I-140 approval from my previous employer, but I never got a green card. I'm now working for a different company and my H-1B is about to expire. So, hold
Yeah.
on. Can my new employer use my old I-140 to extend my H-1B beyond 6 years?
Yeah. So again, that's a good question, and I think a lot of people, I think, will be in that situation. The reason is getting a green card when somebody is born in India or China, the countries that have a lot of retrogression. It takes a very, very long time. And for somebody who's born in India, even though you have an I-140 approved, green card is like a very lengthy process. It takes a couple of decades right now, based on the current priority dates. And people do get better job offers, like as they are progressing in their career, they get better job offers. And USCIS, I think, has made it easy for everybody. So the current rule is, if your I-140 is approved and more than 180 days have passed, so after the approval, uh, tomorrow that I-140 can be used for transfers, for 6-year extensions, for H-4EADs, and so on. So what that means is, you can get a transfer done. Your new employer can use the old I-140 from the other company, and they can use it to get 3-year extensions. So that I-140 is still valid. The I-140 still will belong to you, and you should be able to get 3-year extensions. And the new employer can still use that old I-140 to do the transfer and get you the extensions.
There you go, Ganesh. All the best, and thank you for participating with your question. Now let's take up Sudhir's one, Chand. Sudhir is asking, if my perm is denied but I'm close to my 6 year limit, can I apply for another H-1B under the cap exempt category, or is my only option to leave the US?
You- Um, so normally, if your perm is denied, the company should be able to file a motion or file an appeal, and then go back to DOL, and the doing so. So if your case, so if your company is appealing your denial, the good thing is your company should still be able to apply for 1-year extensions, because the perm is denied. But again, if the company is fighting it and company is filing a motion, filing an appeal, uh, while that thing is in process, your company should be able to file for extensions. So you don't really have to leave the country. And if the company is going to fight your denial, you might be able to get extensions. Uh, and the other question, can you apply for another H-1B under cap exempt category? So if your 6 years is done, because a lot of people will be in this spot where the 6 years period is done, they don't have a perm or they don't have I-140. So to apply in the lottery, to apply in the new H-1B cap as cap exempt, to apply in the lottery, you have to stay out of the country for 1 year. So if you stay out of United States for 1 year, then you can again come back in the lottery. If not, technically you have to argue under the cap exempt category and try for extension. Okay, so you can't go through the lottery if you have been in United States, if not left the country. If you left the country for at least 12 months, then you can go through the new lottery and again get fresh 6 years. But if not, I think in your case, your best bet is your employer will fight the denial, go back to DOL, fight the denial, and based on fighting the denial, based on filing the appeal, you might be able to get 1-year extensions.
All right, so you mean if it is a cap exempt category, it doesn't count within the 6 year limit, does it?
Yeah. So if cap exempt means they don't come under the lottery. So they're exempt from the cap. So what that means is you have to prove that you're exempt from the cap. And the way you'd show it is you'll show that you have been counted in the cap, which in this case it is very easy. He has a previous H-1B approval. So he will show that H-1B approval to show and argue that he's exempt from cap. But then again, the next challenge is, if you're exempt from cap, you can only use a max of 6 years. So if you cross 6 years, you need to have the perm. In this case, since the perm is denied, by appealing and by fighting the denial, he might be able to prove that he's still cap exempt.
Okay. All right. Thank you so much, Chand, for taking that up. And now, quickly saying hi to Srinivas. Thank you so much for joining us on YouTube. I wonder where you have joined us from. And he has a question, Chand. Hi. I completed my H-1B 4 to 5 years out of 6 years back in 2017 and spent 7 years outside US and came back to US in 2024 on extension. Does it reset my 6 year period? I still have 7 months left.
No, it does not reset the 6 year period. So, if somebody has completed four and a half years on their H1B, so when he went out of the country in 2017, spent some time and came back, he is only eligible for that balance period. So he has already used 4.5 years. So the balance period is 1.5 year. So that 1.5 year is what he can use when he's coming back. If he wants to get the entire 6 years back again, you will have to go through the cap lottery, and then by going through the cap lottery, only then you'll be able to get your 6 years back. If not, in your case, because you are using your prior H1B, so whatever is the balance out of that 6 years, in your case, it is a year and a half. That is all you can get, and what that means is you really have to get your perm either certified, or at least it should be pending for at least 1 year to qualify for your extensions.
Right. All the best, Srinivas, and I hope that you figure out soon. Thank you, Chand. And we have addressed some of our questions from the viewers. We will also address some questions from Facebook groups. So, Control, if you can also display them, please. And also, friends, I would like to tell you, you can join us on call. And all you have to do is dial this number 425-436-6335, and the access code is 988-888. And also, please feel free to comment wherever you're watching us right now. And if you haven't as yet subscribed to our channel, subscribe to Immigration Talk Show. That's our handle. And you can also find us on LinkedIn, Facebook, X, and also on Instagram. So this first question, let's take it up. It is from Bilawal. It's from LinkedIn asking, I want to apply for an H-1B visa process. Okay, that is it. So what do you suggest this Bilawal should do?
So yeah. So the good thing is right now the H1B lottery, the H1B registration, it's in process. It just started on March 7th. It will end on March 24th. So the first and foremost thing that anybody wants a H1B should do is find a bona fide and a genuine employer. So that is the very first step. And that employer should be willing to sponsor and have a job offer. So if a company has a job offer, that company will have to enroll somebody, register somebody in the H1B registration process, the process that I just started. After that, more than likely we'll have a lottery. We have been having a lottery every year for the last decade. So assuming that the lottery is done, and if somebody is selected in the lottery, then the company will have to file the actual H1B with United US CIS, United States Citizenship and Immigration Services. And once that H1B is approved, you will have to go for stamping and then come into United States and then work on H1B. So the bottom line is you need to have an employer. You need to have an employer that has a job offer, and that employer should sponsor you, put you in the lottery, get that selection, and once that selection is done, file a formal H1B petition, and then get you into the country to start working on H1B.
Okay, okay. Thank you so much, Chand, for taking that up. And also, Srinivas from some time back is saying thank you. Thank you, Srinivas. And if you have any more further questions, keep commenting. And now let's go on to our next one. This next question is from an anonymous participant asking, hello everyone, I'm currently on H4 visa and I have 11 years plus experience in IT, 7 plus as clinical SaaS programmer, and the 4 years as a senior associate. I need, yeah, I
Senior
need to
associate.
know if someone can help me register for H1B 2025 lottery.
So again, I think it is very important that everybody works with an employer who is reliable, who is genuine. And I think what you should do is you should look at job postings on LinkedIn, Dice, the websites that a lot of technology companies use, More than anything, I think what you should do is you should do your own background research on the company, and Google is like the fastest way to start off research. See if that company has filed H1Bs in the past, if that company is big, and also try to get like some individual referrals. Don't go with, because H1B side, majority of the companies are good, but there is always fraud. And the H1B is something where you should always work with companies that are genuine, that are reliable. And what that means is try to do your own independent research, try to get referrals. I mean, like if your friends have worked with some companies, and it's first-hand information that the company is reliable, that is like always the best way to verify things. And then you always should look at like this reliable websites. And next and the foremost thing that I think I should warn everybody is H1B is something where the employer has to pay the fees. Employer cannot demand fees from you. Employer cannot ask you to pay any fees, whether it is legal fees, whether it is government fee, or whether it is an extra money for doing the H1B process. So my thing is, if a company is asking somebody to pay, they're asking you to pay some H1B fees, the company is definitely, I mean, you have to think twice before going with that company. It is very important that the company pays for the H1B fees. At the stamping nowadays, when somebody goes for stamping, these questions are asked: did you pay for the H1B fees? Has the employer charged you? At the port of entry, even if you get a H1B visa, entry is not guaranteed. At the port of entry, again, that question will be raised. At site visits, that question will be raised. So the bottom line is, if a company is sponsoring H1B, the company has to not only sponsor you, but also has to bear all the fees associated with H1B. And that is one way you know that the company is reliable. And always do your own background research, Google and all these places, and then you cannot pay the H1B fees. H1B fees is something which the company has to pay.
Right, right. And with especially the fee increase, I'm sure that many companies are going to think about who to spend for the $215. But yes, thank you so much, Chan, for taking that up.
Yeah.
And we have more questions. So, Control, if you can display that, please. Mohit is asking, hi all, I find myself in a strange situation. I got laid off today. The company refused to sponsor my visa in November. I have been trying to switch before the lottery deadline, but have been unsuccessful so far. I have 5 months to look for a new role. This could this would have been my last lottery attempt. My STEM OPT ends in January 2016. What are my options? And is enrolling for a day one CPT course worth it? Will employers whom I interview will with willing to bring me on just on my day one CPT? Sorry about my flumming. Any guidance is appreciated.
Sure. So if somebody is on STEM OPT and they got laid off, they can be unemployed for a maximum of 150 days, and that is where I think the 5 months is what the person mentioned in their post. So one can be unemployed for a max of 5 months, and anything more than 5 months will be treated as being uh, uh, failing to maintain their valid status. So up to 5 months, yes, one can be unemployed, but if they cross it, there is a problem, and before 5 months they have to find a job. That being said, uh, because his STEM OPT is expiring in January 2026. And what that means is, if he does not have an H1B sponsor, if he does not have an H1B employer file for him this year, uh, in January,
Mhm.
his STEM OPT is going to expire, and he'll be out of status and he'll have to leave the country. So again, pretty much it is pretty important that he finds a sponsor before March 24th. And if he does not find a good employer, a bona fide employment before March 24th, what that means is more than likely he's losing his H1B chances this year. And come January, he will have to leave the country or change to another legal status. So I think he has a risk. But the good thing is there is another couple of days, and if you find an employer before that time, you get an H1B registration done, you get selected in the lottery, you'll be in good shape. If not, I think I do see a challenge. And day one CPT is always questioned by USCIS. Day one CPT has a lot of restrictions. It is legal. The only thing is you do have to make sure that you're following all the requirements, you're attending classes, you're progressing towards your degree. And not only that, the CPT should be integral to the curriculum, and then there should be a compelling reason why day one CPT is required by that particular university, by that particular program. So for this reason, we always see a lot of RFEs for day one CPTs. So it could be legal. The only thing is, because there is a lot of burden, you always have to think twice and make sure that you're following all the rules of CPT before getting enrolled in a CPT program.
Okay. Thank you so much, Chand, for highlighting some of the challenges of day one CPT as well, and yes, taking that up. So now let's go on to our next one, and this is from Angela. I'm Angela, currently pursuing my business administration degree and will graduate in May 2025. My EAD card is approved and I'll be ready to start work on July 14th, 2025. I'm looking for any job opportunities in business related fields and would love to connect. If you know of anything, okay, this is probably somebody looking for a job, but control if we can have another question and be. This is from Sagnik. My previous visa was F1. Have scheduled a Dropbox for H-1B visa, first time stamping at Chennai for March 7th, 2025. Do I need to channel and schedule office and interview? My hometown is Kolkata. Can I schedule for both office and interview in my hometown? Can I reschedule the appointments now or do I need to wait till March 7th?
I'm not sure. I think the poster's prior visa was F1, and so I think the current visa, I think, is scheduling for a Dropbox H-1B visa stamping. Um, so I think so. What has happened is recently they've changed rules, and now if it is first time H-1B, uh, they still have to go for Dropbox, because in the new rules, what has happened is one is eligible for a Dropbox only if they already had a H-1B in the past. And not only that, that H-1B should currently be active or should have expired in the last 12 months, a very recent expiration of the H-1B visa. If that is the case, now they're eligible for Dropbox. And because of that new rule that came out in February, what is happening is anybody that does not qualify for a Dropbox appointment, interview waiver, all those appointments are being cancelled by the consulates, and they're being rescheduled. So in this case, more than likely, it is better for you to reschedule it if the consulate has already not rescheduled it. If not, more than likely they will cancel your appointment, because in the old rules you're qualified for a Dropbox, but in the new rules, because this is first time H-1B, your prior stamping was with F-1B, sorry, with F-1. You definitely will be called for an interview. You will not be eligible for an interview waiver. So definitely you will have to check with the consulate. Maybe they already rescheduled it. They already canceled your appointment. If not, it's better to reschedule it and go for an in-person interview.
Okay. All the best, Agnik, and thank you so much, Chand, for taking that up. And we have Srinivas actually back again, so I think we should take them up as well. So let's address Srinivas's first. I am in my sixth year of H-1B, and my employer has not started the perm process. I still have 7 months to complete 6 years. Are there any options left for me to continue?
So if the company has not started, so basically when your company applied for your H-1B, more than likely last time they only got 1.5 year. So they did not even probably have received a 3-year approval. So if you look at your approval, you more than likely see that it has been approved for a year and a half, because looks like you've used up 4.5 years previously, and you only have year and a half left. So at the time, you're close to getting your H-1B done. In the current fashion, you more than likely will not be able to extend it. So the only way is your company will have to start the perm process. And if they at least start the perm process, some people, what they do is the company will start the perm process. You go to India, and you're probably working from India, and then that gets you to that 1 year deadline, and then your company will apply for an H-1B extension and then bring you back in. So you definitely will have to talk to your employer and see where your case is, your perm cases, because you more than likely you would have a challenge when it gets to your extension time period. And looks like you don't really have a lot of time for your extension. So just check with your employer to see when your H-1B is expiring. You probably have a copy of your approval, and try to get your perm processing at least started right away, because worst case you might be able to recapture, travel to India, work from India for a couple of months, add that timeline, and then apply for an extension.
Right. Thank you so much for taking that up for Srinivas. Thank you, Srinivas, once again. And we have Sakshi now asking another question. Hi, Sakshi. Thank you. Yes, we could definitely take up your question. And she's asking, can we able to change employer with I-797B consular approved copy while I'm on STEM OPT? What might be the complications involved?
Sure. Definitely, it can be done. We have done that a number of times, and it should not be a problem in general. So the only issue is you're assuming that your approval copy has not been revoked for fraud or misrepresentation. The prior copy, the prior counselor approval copy, if that has not been revoked for fraud or misrepresentation, you should not have a problem. You can either have the same company file for a change of status, you can change your employer, a new employer can file a H-1B for you under change of status or as counselor process. And the way they would do it is they would argue that you're cap exempt, you've been counted in the cap previously, your approval copy is proof that you've been counted in cap, so you're cap exempt, and based on that reason the new employer can transfer and can file a H-1B for you. You should, I mean, unless there is a revocation, unless there is some fraud or misrepresentation in your prior approval, if that has not happened, I don't think you should have any problems at all.
Absolutely. Thank you so much for taking that up. And friends, I would like to tell you that you can also join us on call. Why don't you join us on this number 425-436-6335, and the access code is 988-888. So it'll be really nice if you could join us to ask the questions yourself to Attorney Chand. Sakshi, Sindhura, let's take up Sindhura's comment. I am an F1 visa student and would like to understand my path from F1 to H-1B and eventually a green card. Could you please guide me through the steps through employer versus self employed? Both.
Sure. So the most common way is through employment. So what you would do is you're on F1 visa, and once your F1 program is done, normally what happens is you typically will be eligible for OPT, optional practical training. And when you get your optional practical training, what you do is that gives you an opportunity to find an employer, because the beauty of OPT is you don't need any sponsorship. So because of that, a lot of employers will be willing to sponsor. I mean, will be willing to hire you. So so a lot of people, they use this OPT, get employment, and while working with the employer, they impress the employer that they're a good employee, and then the employer will sponsor the H-1B. So typically, the employer will register you in the H-1B lottery, and then file the H-1B, and then you start working with them on H-1B. And then the employer eventually, what they will do is they will sponsor your green card. And sponsoring the green card is basically filing the PERM, getting through the PERM, then filing the I-140, getting through the I-140, and then you waiting until the date is current to get the green card. And the country of birth makes a lot of difference. So if you're born in India, for example, India is extremely slow because the dates are backlogged. So somebody born in India will take a very, very long time to get a green card. And if somebody is born in Pakistan or Nepal or Bangladesh, for example, because those dates, they come under the rest of the world category, there is not a lot of demand compared to India or China. India and China are countries that have a lot of demand, a lot of retrogression. So if you're not from one of these countries, typically your process is quick. You can get a green card a lot quicker than these two countries. So that is what is the normal process. The other way is self sponsorship. So USCIS, they passed some new regulations this December, and starting from January, they said that you can self sponsor your H-1B. So if you start your own company and you show a business plan, a legitimate business plan, and you show what you will be doing for your own company, you can also self-sponsor your own H-1B. It can be done. The burden is very, very high because you do have to establish a company, and then you do have to show what your company is doing and all those things. But if you have a great idea and you are a startup, you can self-sponsor your H-1B. And that's another route. Self-sponsorship is a little bit more difficult, which is why a lot of people don't go that route. But again, if you have a promising idea, you have a startup, you have probably good funding, that's another way to explore. But the most common way is you will get a OPT, you find employment, you find a good employer, that employer files H-1B, eventually work towards the green card process.
There you go, Sindhura. You have it all there. Thank you so much, Chand, for patiently taking up all these questions and comments for us today in this session. It was very interesting. Well, we also got Sakshi again asking, what should be the minimum pay employer must pay on STEM OPT to employee? Can it be more than I-983 planning training plan? And what should be the minimum in I-983 training plan?
Sure. So the I-983 is a document that the employer has to follow and has to make sure that uh, work is being done as per that particular 983. And when you talk about minimum pay, H-1B has a minimum wage. So if somebody's on H-1B, you look at the LCA, and the LCA is the minimum that an employer can pay. And when it comes to STEM OPT, the minimum is so USCIS does not say a per se minimum. There is nothing like an LCA requirement, but there are state minimum wage laws. So every state has a minimum wage law. So for example, Texas, it is $7.25 per hour. That's the minimum. Anything lower than that, DOL will immediately step into the picture, and it is a violation of law. And again, some states, for example, some states have $15, some states have more than that. So every state has something called minimum wage, and you can just Google your state and say minimum wage, for example, state of New York, for example, you will see the minimum wage. So no employer, no company can pay anything less than the minimum wage. So pretty much every employer is required to pay at least the minimum wage. That is the general rule. And on top of it, normally what the companies are supposed to do is they're supposed to meet industry standards. So if company is like completely like paying very very low, suppose the industry standard is the range is like this to this, if the company is like depressing the wages, paying a very very low salary, tomorrow if there is an audit, that company will have to explain, because the goal of the OPT program is not to depress US wages. So the company should try to keep wages at a market level. So even though legally on a DOL side, the minimum requirement is meet the minimum wage, in general, the good practice is the companies should not use the OPT program to depress the US wages. They should meet the market wages. And everybody's role is different. If somebody is working as a software engineer, it is different. If somebody is working as a pharmacy trainee, for example, things are different. If somebody is working as a validation engineer, again, depending on what state you are working in Texas, it is a different wage. New York City, it's different. Bay Area, it is different. If it is a small town, it is different. So that is why what the company should do is they should make sure they meet the minimum wage on a bare minimum, and on top of it, they should match whatever is the market standard in that particular city for that particular role. And if they pay more than that, it is always good. If they pay less than that, that is where there are problems from USCIS, DOL, sometimes even DOJ, because sometimes if things are not being followed and it is depressing US wages, or there's some kind of discrimination or something of that sort. Sometimes we see even DOJ, Department of Justice, step in, because sometimes people try to hire people on a specific work visa because they feel that they can give low salary. So we have seen cases where DOJ will interfere and say you're discriminating and preferring people on this particular visa status to pay them a lower salary than the industry standard. So there are so many things. The general rule is if the company follows market standards, they will be in good shape.
Thank you so much, Chand, for taking that up for Sakshi. Sindhura says thank you. Thank you, Sindhura, as well for your question. And now, Geeta. We have I-140, and in the month of June, we have to renew our H-1B. What challenges to renew?
So if you already have an I-140, at least you will not have any problems with the 3-year extensions. So the 3-year extensions part, it's not a problem at all. So the next challenge is the company making sure they have a bona fide job offer and proving to USCIS. Prior to January 18th, the rules were a little bit different. Starting from January 18th, they added some more additional burden. Now you have to, if you're working on a client project, you have to show the nature of their assignment. So maybe a purchase order, maybe client vendor letters, etc. So as long as the company is making sure they prove that the job offer is bona fide, they prove that the company is legitimate, I don't think you should have any surprises in your H-1B. So at this point of time, in the last 1-2 months, yes, we are hearing a lot of rhetoric about immigration issues with immigration. But on the H-1B side, I think the new government, I think they're still in favor of H-1Bs. We are not seeing any bad RFEs. We are not seeing any approvals, short-term approvals. Prior to 2020, we used to see short-term approvals, 1 month approval, 2 month approval, 1 year approval, and so on. In the current administration, at least we are not seeing short-term approvals. As long as the company is legitimate, they're able to prove to USCIS, you should not have any problem. I think things are still smooth with the H1B
Okay.
approvals.
Okay. Well, thank you so much, Chand. Yeeta, thank you so much for your question. And also, don't forget to like Immigration Talk Show. Also goes the same to all you folks out there. I'm sure that you resonated with Chand's response to your questions. Sakshi and also Sindhura, Yeeta, everyone actually. So thank you so much for your questions and for joining us with your questions here on this episode we had today with attorney Chand Parvathaneni. And please feel free to also contact him, for your consultation, or maybe you really need attention. You need an attorney to guide you with your case. Then why not contact attorney Chand on his number? His number is 817-523-8247. And also you can email him, and his email address is law@spblawfirm.com, and go visit www.spblawfirm.com. Also, when you contact him, do let him know that you watched him here on Immigration Talk Show, and he'll be happy to help you and to even know that. So, thank you so much. Yita also says, thank you very much for your answer. Thank you, Yita. And Chance, before we leave, if you have any end note, to leave folks out there watching us right now. Um, yeah.
Sure. So one of the things that has been happening with the H1Bs and the PERMs and I-140s is the timelines are very, very bad. I mean, again, this is nothing to do with the new Trump administration. This has started in Biden administration. The PERM, what used to take, what used to be a very, very a fast process, now has become a very, very long process. They've not changed the rules. It is just that the adjudication timelines have increased. So perms are taking almost 15 to 16 months to be adjudicated. And because we have the 6 year limit on H1Bs, I think, and things are not like what they used to be a long time back. Uh, Long time back, we used to see perm approvals 4 to 5 months, used to be common. Definitely, what we're seeing now is kind of pretty rare. And moving forwards, I don't think the times will shorten. I think the times probably will stay the same. And for that reason, I think everybody that does not have an I-140 or perm filing done, you should always like work with your employer and see what they're doing. And if you feel that your employer is not a reliable employer who you think will file the perm process for you or go through the I-140 process for you, you should remember that there is a 6 year limit. So either you have to leave the country after 6 years, or you find another employer, a reliable and a genuine employer who would be willing to sponsor your perm. Because if that is not done and it is sixth year, you'll be like going back and forth, and then you'll be in a very, very bad spot. So everybody be conscious of that 6 year limit and then the importance of perm, and do not wait until the last minute. So doing so, you'll have very less surprises when it is your sixth year on H1B.
Absolutely. Thank you so much, Chand, for joining us today and for sharing with us all these expertise and this knowledge that you imparted on today's webinar. Very important points, and I hope that friends out there took notes as well. And even if not, you can always rewatch this whole episode. Thank you for joining us. It's Immigration Talk Show. Do follow us, hit that bell icon so that whenever we have discussions like these, you are notified. And also, you can call me. You can leave a message on my WhatsApp as well. And my number is 408-335-6444. And you can email me at nipa@staffingly.com. And that's it. Thank you so much, Chant, once again. I'm really looking forward, to for you to join us maybe in the coming week. So yes, thank you everyone for joining us, and for those celebrating Holi, which is a festival also. Happy Holi ahead, and yeah, thank you for joining us today on Immigration Talk Show. It's Nipasa saying bye for now.